कमिटी गोटे हाई पावर कमिटी सेक्रेटरी रैंक ऑफिसर हूँ ये जिनस एग्जामाइन करूँ एग्जामाइन करते दूर यह ग्रहण योग्य ताकू देखंतु जदि यह योग्य पाइबा जड़े हकदार अच्छी ताकू आपण कनसीडर करि पारंती जोटा कि सुप्रीम कोर्ट आज ये जो जजमेंट देते हैं स्वागत योग्य जजमेंट जो आमर लिमिट्स अच्छी जुडिशियरी एग्जीक्यूटिव लेजिस्लेटिव कार कौन डोमेन अच्छी सुप्रीम कोर्ट आज इंटरप्रिट कर इट इज ए कंप्लीट डोमेन ऑफ द पार्लियामेंट
अनमैरिड कपल्स एवं ट्रांसजेंडर्स कपल्स दे कैनॉट एडॉप्ट सेठी कोहल करछंती चीफ जस्टिस ऑर्डर रे जजमेंट रे से कहले से गाइडलाइंस अनुसार कारा गाइडलाइंस रे जो रेस्ट्रिक्शंस अछि से रेस्ट्रिक्शंस ता हटिबा दरकार विथ ड्यू वेरिफिकेशंस इवन अनमैरिड कपल कैन एडॉप्ट इवन ट्रांसजेंडर कैन आल्सो एडॉप्ट किंतु जो मेजर एमानकर डिमांड्स थिला जो मैरिज इन स्पेशल मैरिज एक्ट रे कि क्वेयर कपल्स कैन मैरी से पार्टा को समस्त जज एकमत होगी सेटा कहले जे सेटा दैट इज एन एरिया व्हिच इज द एरिया ऑफ द लेजिस्लेशंस तो सेटा केवल गवर्नमेंट Constitution, a parliament can only deal with it.
The majority view which has been taken by Justice Bhatt Narasimha, Justice Narasimha and Justice Kohli has been, that marriage is not a fundamental right. And they have expressed that opinion not just in light of LGBTQI couples, but also in light of the heterosexual couples. They say that the marriage as a concept it derives its roots from the social institutions which have been prevalent in the country, and law only seeks to regulate it.
सुप्रीम कोर्ट ने आज स्पष्ट कहा है सुप्रीम कोर्ट के सामने डिमांड की गई थी दो डिक्लेरेशन ऑफ मैरिज एज अ फंडामेंटल राइट एंड रिकॉग्निशन ऑफ सेम सेक्स मैरिज सुप्रीम कोर्ट ने दोनों ही को मना कर दिया है सुप्रीम कोर्ट ने आज स्पष्ट अपने फैसले में कहा है कि वो फंडामेंटल राइट डिक्लेयर नहीं कर सकता है शादी विवाह को शादी विवाह जरूर आपका अधिकार है लेकिन वो मौलिक अधिकार नहीं हो सकता है और दूसरा कि अगर वो इसमें सेम सेक्स मैरिज की आप बात करें तो हम उसके भी पक्षधर नहीं है सेम सेक्स मैरिज का जो अधिकार है अगर वो देना होगा तो वो विधायपालिका यानी कि पार्लियामेंट का ही है सुप्रीम कोर्ट का नहीं है
इस फैसले को बहुत निराशाजनक है हमारे लिए तो जस्ट बिकॉज ऑफ क्योंकि जानने के लिए कि हम जितना चाहते थे जितना करते उसमें हमें निराशा ही हाथ लगी कि और कितना हम एफर्ट्स लगाएंगे बट कोई बात नहीं हम और अपना एफर्ट्स लगाएंगे और लड़ेंगे अपने लिए और खड़े होंगे फिर से जितने भी चीज़ें बताई गई पार्लियामेंट को सौंप दिया गया ये सारा का सारा चाहती हूँ कि एक मेरे लिए हक हो मेरे को एक नाम मिले मैं नाम चाहती हूँ कि जिसके साथ में रह रही तो उसके साथ में मेरे पार्टनर का नाम जुड़े बहुत सारी ऐसी चीज़ें कि इस चीज़ में हम आगे जाके हमें बहुत ज़्यादा और फेस करना पड़ रहा है अभी भी और करना पड़ेगा कोई बात नहीं हम फिर और लड़ेंगे इस चीज़ के लिए
Well, yes, I mean, I would say we have edged closer, certainly, right? There is a talk about declaring us into a civil union, right? Okay, so I am hopeful, probably that in the long run it will materialize into something more, favorable for us, right? Because many of the judges have spoken in our favor, so I'm hopeful that eventually their word would spread across. And personally, I don't have much hope with the parliament, but yes, at least Supreme Court has, given us a ray of hope that probably in the future, okay, the parliament would look into it, form a committee so that, we can further get, more equality in this country in this regard.
संपर्क अधिक आलोचना करवा विश्वजित दास वरिष्ठ आईनजीवी आम सहित फोन लाइन में जोड़ी होती श्री दास स्वागत करुच्ची नंदीघोष टीवी की ई राय को केमती देखुंट सुप्रीम कोर्ट वर्तमान केंद्र कोर्ट को सुप्रीम कोर्ट बल फिंगी संसद रे आईन प्रस्तुत हो पार केंद्र ए आईन प्रस्तुत कर राय को केम देखुंट सुप्रीम कोर्ट
वेल आपण जानछंती बाय नाउ यू मस्ट हैव डिस्कस्ड इन ट्रेड डे आपण मानकर अदर वक्ता माने कहिसंती actually this is a split verdict as far as the recognition of a marriage as a fundamental right is concerned. While minority judgment presided authored by Justice current Justice Chandrachud, so jehetu kahishanti je yes as part of evolution the court has a power also to mold the constitutional provisions article 19, 21, 15 and therefore the marriage, the concept of marriage per se, between, one human choosing to another human, whether it is heterosexual or homosexual, this is intrinsic to identity with human rights. And therefore, it's in a way, it can be treated as a fundamental, while the majority judgment presided, authored by Justice Bhatt, has stated that no, this is marriage as a concept, because it is born out from the Hindu Marriage Act, Special Marriage Act as a legislative concept, therefore it is a statutory right. So that is a disagreement as far as this point is concerned, number one. Number two, therefore, as a corollary to it, they have said that the majority view is that the same-sex marriage or LGBTQ, QI, class of gender sexuality, they cannot get the benefits of the largesse which is given as part of a consequence of recognition. I mean, legislative recognition as a marriage. That is not given, but that does not mean that the state will create any discrimination amongst these class of people, and therefore adoption per se, that may not be also possible. So marriage per se between the same sex also not recognized by the legislation, and therefore only the legislature through amendment to the existing legislation to bring about that. And in the meantime, the interesting aspect actually is all the members of the bench have agreed that the government of India has already, during the course of hearing, recognize and understand, evaluate that what are the rights are there which is getting impeded by the existing legislation, and how, whether the authorities under those statutes are exercising power in a non-discriminatory manner. That is a committee is getting constituted with the chairmanship of your cabinet secretary, and that all the state government, the union territory, and all the central government, they are all will try to present before that particular committee and try to come out with their recommendation as to what should be the nature of the discriminatory exercise of this statutory function. So in a way, yes, this for the time being, one can very safely say that the Supreme Court has already debunked the idea of recognizing through a existing legislation, that the same-sex marriage or the adoption by the homosexual is permissible, because ଆପଣ ଜାଣିଛନ୍ତି ନାହିଁ କାରା ରେଗୁଲେସନ ଯୋଉଟା ଅଛି ଆପଣଙ୍କର ସେଣ୍ଟ୍ରାଲ ଅଥରିଟି adoption authority ସେମାନଙ୍କର ଯୋଉ ରେଗୁଲେସନ ଅଛି ଯେ only heterosexuals can adopt or individual can adopt, but the homosexual cannot adopt, and therefore ସେଠାରେ ବି ଗୋଟେ ଚ୍ୟାଲେଞ୍ଜ ହେଇଥିଲା ଯେ how can a individual can adopt but a homosexual cannot adopt. But for the time being, the controversy is settled by the 5th Constitution bench to the effect saying one thing is very clear, that the marriage as a concept is a statutory concept, and therefore this is only a statutory nature. Therefore, every condition of that, so it is always the marriage is a conditional in nature as part of a society as it evolves. Whatever the conditions, whatever the your practices are being accepted by the society, now codified in the legislation, you cannot say that the marriage will happen, but you will not be adopting the conditions of that marriage. So therefore, whatever the legislative conditions, whether it is Special Marriage Act, whether Hindu Marriage Act, whether adoptions, Hindu Adoptions Act or whatever, all these statutes for the time being are treated to be constitutionally valid law, and there is no violation, whether on the count of Article 14 or the count of 19, 15, 21, ତେଣୁ କନଷ୍ଟିଟ୍ୟୁସନ ର ଯେତେ ବି ପ୍ରାବଧାନ ଆପଣ ନିଅନ୍ତୁ, ଯେତେ ବି ଲାଇନ୍ ଅଫ୍ ଚ୍ୟାଲେଞ୍ଜ ହେଇଥିଲା, ସବୁଗୁଡାକୁ ଖାରେଇ ଦେଇଛି ଇନ୍ ଦ ମେଜରିଟି 3:2.
ଆଜ୍ଞା ସାର୍, ବହୁତ ବହୁତ ଧନ୍ୟବାଦ ସାର୍ ଆପଣଙ୍କ ମତାମତ ପାଇଁ। ବିଶ୍ୱଜିତ ଦାସ ବରିଷ୍ଠ ଆଇନଜୀବୀ ଥିଲେ, ଏ ସମ୍ପର୍କରେ ଅଧିକ ଆଲୋଚନା କରୁଥିଲେ।